Hi friends, welcome to StudyIQ. In this video, we will be discussing the various judgments which were given by the Delhi High Court in 2018. The judgments were so important that they can now be also called as milestone judgments. They are called as milestone judgments only because of the fact that their implications will be very huge on the society and polity and economy of the Indian society, okay, which is why it has also been called a landmark year for the Delhi High Court. My name is Anirudh. Just a short introduction about myself. I am currently working as Deputy Superintendent of Police in the Prisons Department in Punjab government. I had cleared Punjab State PCS in 2015. I have also appeared in Civil Services Examination Mains 3 times. As far as my educational background is concerned, I have done my BTech from IIT Madras. Okay, so we'll now directly move on to the Delhi High Court, how it was a torch bearer of major reformation in society in 2018. Alright, so there are 3 or 4 major facets which we can discuss over here. First of all, the decisions transcended state boundaries in its implications, meaning that there were certain decisions which the Delhi High Court had taken which had implications not only for Delhi but also for the neighboring states like Haryana. Then secondly, there was also a major step taken by Delhi High Court, which was that the shifting of cases was done to Delhi High Court in order to ensure that the trial was fair. Now, fair trial is a very important part of judiciary. In order to ensure that, Supreme Court had shifted a couple of important cases to Delhi High Court so that the victims can get the benefit of a fair trial. Then not only that, the Delhi High Court also took some steps in the area of begging. What it did was it decriminalized begging in the capital, citing various issues which should not be ignored. Alright. Then apart from that, it also played some steps for women empowerment. It opened certain new avenues for women in the forces. In this case, we are talking about the territorial army, whereby the Delhi High Court judgment is remembered because it opened the avenue for women to get recruited into the territorial army by modifying the Section 6 of the Territorial Army Act. Then most important, according to me, and my personal favorite of all the judgments was this one, where Delhi High Court said that perpetrators of mass crimes will not escape prosecution even if they enjoyed political patronage. So people who have committed mass crimes or people who have organized mass crimes, they will not be escaping prosecution and punishment despite the fact that they enjoy some kind of political patronage, that they already have some sort of political influence. Okay, this was a very brief introduction of what all Delhi High Court did. Now we will directly move on to the various judgments which Delhi High Court gave. In this video, we will be discussing 7 major judgments. So the first one, the Mirchpur riots. The case was languishing since almost 8 years, and finally the decision has come. Just to give you a very brief idea, where is Mirchpur? It is a village in Haryana, in Hisar district. So in 2010, a caste violence incident affected Mirchpur village in the state of Haryana. 8 years now, the Delhi High Court gave a judgment in 2018 which convicted 4 persons of murder and 28 others for other crimes from the Jat community of rioting. Alright, so it was a communal incident. It was the incident whereby the dominant Jat community had inflicted certain wrongs on the minority Valmiki community. We will see how the events panned out. So in the beginning, the trigger of the incident was, as you can see, the trigger was a very seemingly insignificant event, very trivial event which should not have had any repercussions. A dog which was belonging to the Valmiki resident of the area, he barked at a group of Jat youth. The dog had just simply barked at a group of Jat youth, out of which the reaction of the dominant community was they burnt down 18 houses belonging to the Valmikis And very unfortunate incident was a 60-year-old Dalit and his differently abled daughter were burnt alive. This was a nerve-shocking incident. What was the impact of the entire incident on the minority community? At least 254 families had fled the area in the aftermath of the riot. They had to flee the area out of fear. And 8 years now, many of those who fled are yet to return. So some people have not returned even now to their houses, to the village of Mirchpur. Now, in all this, what was the role of Delhi High Court? So over the image where you can see, here are some instances of how the houses were burnt. And okay, so this, you can see here, properties of the Valmikis were burnt and the belongings were damaged. This was an instance of caste-based violence to teach the Valmikis a lesson for the perceived insult caused to the Jats. Okay, the Delhi High Court, what it did was, in December 2010 itself, the Supreme Court ordered shifting of the case from Haryana to Delhi because it wanted a fair trial to be conducted in Delhi High Court, because there were apprehensions, there were certain considerations that the state of Haryana might not be able to conduct a fair trial in this case. So the Delhi High Court, it overturned the acquittal of 20 persons. The 20 persons were acquitted initially. Now, very important fact which was noted on by Delhi High Court was that even 7 decades after independence, it's nearly 70 years have passed since independence, but the atrocities or crimes on the communities belonging to the scheduled caste have shown no signs of abating. So abating means reducing. So the signs have not reduced, they have not diminished. Okay, the atrocities on scheduled caste continue to occur. Second most important, which was noted down by Delhi High Court, was the atmosphere of fear created by the members of the dominant Jat community was evidently so severe that the confidence of the members of the Valmiki community, the minority community, about their safety and security in Mirchpur is yet to be restored. So this is, as you can figure out from this entire thing, that it is a very communal sort of an incident. The dominant community affecting or inflicting pain over the minority community. So the reason why I discussed this judgment over here, this so important judgment over here, because this you can utilize very much in your mains examination. So before I started the video, I wanted to tell you that this video is primarily targeted for mains examination. It will not serve much purpose for prelims examination. This fact you can use in GS1 communalism, okay, in Indian society, whereby you encounter questions such as, does communalism still occur in the Indian society? So this is where you can use this example of that, yes, caste-based violence is still evident and it can still be seen. Also, you can also use an example in the Prevention of Atrocities Act of 1988, where you can show that the implementation of the act has not been so effective because atrocities and crimes continue to occur against the scheduled tribes and the scheduled castes. Also, you can use this example in the case of GS2, where you have topics of various development groups and various vulnerable sections of society, whereby you can use this example. And you can also quote, especially you can quote this in judicial activism, how judiciary took an active step to ensure a free trial and brought justice to the affected people of Mirchpur by the Delhi High Court judgment. And always you can use such examples in the case of an essay. Okay, so these are very useful examples. And also one more thing I want to emphasize over here, which I will keep emphasizing throughout this video, is that if you are able to memorize or remember some of the phrases which were used by the Delhi High Court in the judgment, you can always get some brownie points for that. All right, that will always help you, because those are the words used by the government in its own judgment. Okay, so moving on to the next judgment. This is again a case of communalism. The Hashimpura massacre was in news, and I'm sure all of you know the entire story, all the events. I've just brushed up the events for you, and I have just tried to show you what the Delhi High Court said in the official statement in this case. All right. So beginning by, where is Hashimpura located? Again, this is an area in Meerut district of Uttar Pradesh. All right. What happened here? 1987, 38 Muslims from Hashimpura were rounded up and shot by the UP Provincial Armed Constabulary, which we now call as PAC. Okay. They were rounded up and shot by the PAC. 2018, 31 years after the incident happened, the final judgment came, which sent 16 former PAC Jawans to life imprisonment for murder of 38 Muslims. Now the events in brief, what exactly happened at that time. The shooting happened in 1987. Around 45 men and young boys from the Muslim community were rounded up, packed into a truck and taken away. They were taken away. And the most unfortunate part of the entire event was they were shot with the state issued rifles. So the constabulary, which should be working in the interest of the citizens, they are instead using the armed weapons to fire at the people. Some of the bodies, innocent people, some of the bodies were dispatched into Gang Nahar Canal, the others into Hindon River. Some people who survived, the 5 people who survived, they managed to recount the horrific tale, which is why we today have a judgment against those 16 Jawans of PAC. One important thing over here was 2002, which you should note down. Earlier, before 2002, in 2000, the 16 of the 19 accused personnel surrendered, but they were released on bail, and 3 of them died during trial. 2002, Supreme Court shifts trial of the massacre from Ghaziabad to Tis Hazari Court, again in order to ensure that fair trial is not compromised. What happens in 2015 in the Tis Hazari courts is that the court acquits the 16 accused due to insufficient evidence. Okay. Now, after this 2015 incident of March, this is where the role of Delhi High Court comes in. The Delhi High Court quashed the 2015 trial court judgment, which exonerated them of the crime. Which exonerated meaning that which proved that they are not guilty. Now come what the Delhi High Court says. Now comes what the Delhi High Court said. This was a case of targeted killing, revealing an institutional bias within the law enforcement agents in this case. These are very important keywords and very important phrases which you can readily use. Okay, the High Court had noted. Secondly, the Delhi High Court ruled that this case is yet another instance of custodial killing, where the legal system has been unable to effectively prosecute the perpetrators of gross human right abuses. All right. So there are 3 to 4 things which directly come out of this judgment. But before that, I'll want to add one more thing which the Delhi High Court had noted. That the prolongation of the trial for over 2 decades, the delay or the prolongation, the stretching of the trial for over 2 decades, compounded by the endemic systemic delays, have frustrated the attempts at securing effective justice for the victims. Okay, so now slightly doing an analysis of the Delhi High Court judgment, what it said was over here. First of all, this was a case of targeted killing, revealing an institutional bias. So this is the first and foremost important thing, and my personal favorite from this entire judgment, that the case reveals an institutional bias within the law enforcement agents in this case. This one phrase is such a beautiful phrase, and it reveals a lot of things about the law enforcement agencies. Second thing is custodial killing. Third thing is human right abuses. Okay. And the fourth important thing is the delay, which was faced by the trial for over 2 decades, almost 3 decades rather. Okay. Now, how will we be using this judgment? First of all, again, this is an incidence of communalism. So GS1 is mains. I'm sure you understand that. Communalism, okay, in Indian society. So over there you can, now there are 2 aspects which you can use from this. First of all, again, does communalism still exist in India? Is India still affected by communalism? So yes, it is, which we can say by first of all by the Mirchpur riots, then we can say by the Hashimpura massacre. Secondly, sometimes the question asks you, what should be the way forward? How should incidents of communal violence be handled by the law enforcement agencies? So which is where you use this example of institutional bias, that there is a dire need for sensitization of police forces and law enforcement agents, so that the institutional bias should be eliminated, so that they can do their duty in a fair manner. All right, so this is again which you can use in communalism. Secondly, you can also use this part in GS2, whereby we talk of autonomy of institutions. Okay, over there we can use that the autonomy has been misused by institutions at number of places, because an inherent institutional bias has been created by the law enforcement agents. Now the next part, which custodial killing and human rights abuses. So this is something which you can, where you can link this in the syllabus, is GS3. Okay, custodial killing and human rights abuses, GS3. We always have read this in AFSPA, how the army has misused the powers of AFSPA and how it has become a critical point of the AFSPA Act. Similarly, we can see in this case that human rights abuses have been committed and custodial killings have also been done. Now, the reason why we can use these phrases is because the Delhi High Court has said this in the judgment. Okay, otherwise you might say that using such phrases might backfire on you or might not be very useful for you. But in this case, the Delhi High Court has directly used these phrases, so you can also use them in your examination. Okay, so I hope you can, this is how you can use them, you understand that. Now coming to the judicial delay, this is also one major thing we can use in GS2, whereby a question on judicial delay can always be asked. So over there you can always write about the impact of judicial delay, how it has impacted the religious minorities. Now in the larger picture you can say that yeah, it has impacted the overall Indian society, but in this case it has impacted the religious minorities, which should be protected by the constitution, which are to be protected by the constitution. How are they impacted? Because the effective justice was not ensured by them for over 3 decades. This is because of the overburdening of the judiciary and because of the way the system works. As you can see from here, the endemic systemic delays, which the phrase has been used by the Delhi High Court, that endemic systemic delays have frustrated the attempts at securing effective justice for the victims. Alright, so this is how you can use this in GS2. Alright, chalo, so we'll move on to the third part now. The first two we discussed were based on communalism. The third one is also based on communalism. Another very important judgment, for which you can say better late than never. 1984, everybody knows what happened. Killing of nearly 3,350 Sikhs in Delhi between November 1 and 4, 1984. I will not be commenting or debating upon the figures which are mentioned over here, okay, because these are government figures and some believe that the non-government figures have crossed even 10,000. Anyhow, now what happens in 2018? The Delhi High Court convicted Congress leader Sajjan Kumar for the killing of 5 Sikhs in Rajnagar and sent him to jail for the remainder of his natural life. Alright. Now, as you might be aware, Sajjan Kumar had also filed a petition in the Delhi High Court asking him to give him time for surrendering till January 30. But that petition was denied and he had to surrender on January 1st, I guess. So he surrendered a couple of days ago. Okay, so what was the role of the Delhi High Court in this case? We will not be discussing the events because the case was going on for a pretty long time over here. What happened here? Delhi High Court used the phrase crimes against humanity. Alright, crimes against humanity, the phrase was used for the killing of 3,350 Sikhs. The court also noted that the riots were engineered by political actors with the assistance of law enforcement agencies. So this is a very similar instance which we saw in the previous example of Hashimpura massacre, how the law enforcement agencies have not worked in a fair manner. They have not worked in public interest. Now, another important thing which was added here was that the entire riots were engineered by political actors. So this is where you see the influence of politics on communalism. Again, you can use this in GS1 communalism, how politics can also influence communal violence in the country. Okay. Thirdly, the Delhi High Court observed that a majority of the perpetrators of the horrific mass crimes in the riots enjoyed political patronage and escaped prosecution and punishment for over 3 decades because they enjoyed political patronage. Okay. Now this is a very important thing which has been said by Delhi High Court, and I think this can come in very handy while framing our answers, that political patronage should be dealt with without any tolerance by the judiciary of the country, so that they cannot escape prosecution and punishment. Now, another important thing which the Delhi High Court did in this case was it recounted various other events. What other events were recounted? Like this is again you can use as examples. The Delhi High Court said that Mumbai 1993, Gujarat 2002, Odisha 2008 and Muzaffarnagar 2013. These are various such instances where we see political patronage being happening, due to which the perpetrators were escaping prosecution and punishment. Another important thing observed by the Delhi High Court was common to these mass crimes were the targeting of minorities and the attacks spearheaded by the dominant political actors being facilitated by the law enforcement agencies. Now, this might seem a very simple statement to you, but I'll tell you what is so special about this observation by Delhi High Court. There are 3 things: targeting of minorities, spearheaded by dominant political actors, facilitated by law enforcement agencies. So there are 3 characteristics of mass crimes or communal crimes which we can observe in the country. One is generally the minorities are targeted. Secondly, the dominant political actors also sometimes play a role, as we can see in the anti-Sikh riots or as we can see in these 4 cases. Okay, so this is again another characteristic. Thirdly, they are also being facilitated by the law enforcement agencies due to an inherent institutional bias, as we can see in anti-Sikh riots and as we can see in Hashimpura massacre. Okay, so these are the 3 things, in a way 3 characteristics which we can see in the case of communal violence occurring in India. Alright, so now coming to how you can use this in your examination. Okay, this is a very beautiful phrase. Please remember this phrase. First of all, again, GS1. So all the 3 cases which we have discussed, and according to me, these three cases had very huge implications for the Indian society. You can use in communalism. Okay, Indian society part. Secondly, in the GS2, where we talk about the transparency and accountability of political parties and how they should be functioning. Over there, you can also use that political patronage has been provided by the political parties to many perpetrators of mass crime. Okay, which is why they have been escaping prosecution and punishment. So this is a practice which should be discouraged at all costs. Then also you can talk about judicial activism, how the judiciary actively took up the major step to convict a person who enjoyed political patronage without any fear of any backlash. Without judiciary utilized its independence and authority to convict a person of who was having a very high political influence. All right, so this is where you can use this in GS2. Okay, so this is how you have to use these examples, as in these, nobody will tell you how to actually write this in your answers. I'm doing the task over here for you, that I'm giving you examples out of the High Court judgments, and I'm telling you how to use those judgments. You can also use this in GS4 in case studies, whereby you can tell if, let's say you get a case study where you are the DM of a particular area and a caste-based violence has occurred, what should be the steps taken by the executive in that case. So that is where you talk about that the law enforcement agencies should act in a transparent manner and should always uphold the public interest and not uphold the interest of any majority community. All right. So these are certain things which you can take home from this judgment. All right. Now, coming to the next judgment. Now, this was a judgment which the High Court gave in public interest. The beginning of 2018, I guess February, the High Court gave a verdict which ended discrimination in health insurance policies. Now, prior to this judgment, what was the scenario? Before this judgment, the health insurance was not available to people who suffered from genetic disorders. All right. So there was a person who had filed a PIL in this case. The disease which had affected that person is not important over here. However, the judgment is really important. So because of the genetic disorders, the health insurance companies, they had excluded the genetic disorders from their policies, which is because such disorders incurred very high costs. What the Delhi High Court did, the High Court ruled that a person suffering from a genetic disorder needs medical insurance as much as anyone else. Okay. Now, the very important part of this judgment, the exclusionary clause of genetic disorders in the insurance policy is too broad, ambiguous and discriminatory, hence violative of Article 14 of the Constitution. So, whenever it is discriminatory, it is obviously violative of Article 14 of the Constitution. The court noted also that right to health insurance is a part of the fundamental right to life. So, the fundamental right to life we can see in Article 21. This in a way becomes an inferred right. This is a fact which can be asked in the prelims examination also. Is the right to health insurance and part of the fundamental right of life? Yes, it is, because it is an inferred right as per the Delhi High Court judgment. Secondly, you can also utilize this in GS2, whereby judicial activism. Now, this is another example of judicial activism whereby the judiciary is doing the work of executive in this case, because after this judgment, the judiciary also directed the IRDA, the Insurance Regulatory Development Authority of India, to take a look at the exclusionary clauses in insurance contracts and ensure that insurance firms do not reject claims on the basis of exclusions relating to genetic disorders. Then further, Justice Singh highlighted that there are different types of genetic disorders and common diseases like diabetes and cardiac diseases which could be included in the broad definition. Okay, now this has broader implications for the society. How? First of all, health expenditure. Okay, out of pocket expenditure, which is generally a very contentious issue when it comes to the health infrastructure or the health system in India. It is very high, alarmingly high. Okay. In order to cut that, the health insurance should be extended to as much ailments as possible. So the Delhi High Court stood up and did that in the case of genetic disorders. Okay, this is a very important part of GS2, where you talk about development sectors. All right. So this is how you can utilize this judgment in that case, that how health insurance should be included for various ailments, which can eventually reduce the out-of-pocket expenditure of the people. Okay, I've already told you that this is an inferred right. This is also, you can use how the judiciary upheld the Article 14 of the Constitution. So there are a number of things which you can take home from this judgment as well. All right. Now coming to the next judgment of interfaith marriage. Now, under this judgment, what happened was in 2018. So in order to understand this judgment, first of all, you will need to understand the SMA, the Special Marriage Act of 1954. This is a very simple act. Before I move on to the judgment, I'll just tell you about the SMA. What is the SMA? So the SMA provides a special form of marriage, its registration and its divorce. So the three things are being provided by the SMA: special form of marriage, registration and divorce. Secondly, a marriage between any two persons belonging to any religion or creed may be solemnized under this act. Now this is an act which was brought in to promote interfaith marriage. Interfaith marriage or inter-religion marriage under the SMA. It is therefore a secular law. You can also call it a protection against moral policing in a way. This clause we will be understanding in the further slides. Now coming to the judgment. A person who marries under the Special Marriage Act and then converts to the partner's religion is entitled to invoke the jurisdiction of a family court instead of the personal law for dissolution of marriage. Let us understand this through an example. Suppose there is a marriage between a Hindu and a Muslim, Hindu boy and a Muslim girl. Okay. When the marriage is occurring, they have registered the marriage under the SMA 1954. Now, after the marriage has been solemnized, one of the persons converts to the other person's religion. Let's say the Hindu, let's say the Muslim girl converts to the Hindu religion. So now both are Hindu. And let's say now there is a complication in the marriage. Now, this complication can be regarding the divorce. It can be regarding succession of property. Alright. It can be regarding maintenance of divorce. That how the affected party wishes to be paid, wishes to be maintained after the divorce. Okay. So in this case, now let's say one of the parties moves for divorce. When they move for divorce, they cannot invoke the personal law. They have to settle the divorce as per the SMA. Now, even though both are Hindus, or even though let's say both can be Muslims also in this case, even though both are Muslims or both are Hindus, they cannot be invoking the personal law. They have to invoke the Special Marriage Act only, under which they initially got registered their marriage. In this case, we will understand what were the events which happened. The parties in this case got married under the Special Marriage Act in 1998. They had a nikah ceremony. It is a Muslim ceremony. 4 months later, in 2014, the wife moved the family court for divorce. After 16 years of the marriage, the wife went to the family court for divorce. The man in this case, he challenged the maintainability of the proceedings which were being heard as per the Special Marriage Act. Over here, the man said that the proceedings should be as per the Muslim personal law. Okay, and not as per the Special Marriage Act, because they had also performed a nikah ceremony after the marriage. Now this is where the Delhi High Court comes in. The Delhi High Court said that they dismissed the man's petition that the divorce proceedings are not fair. The Delhi High Court dismissed the man's petition, and also the High Court ruled that the family court has the jurisdiction to entertain and try the divorce petition. So it retained the powers of the family court. The High Court also directed the family court to expedite and decide the women's petition for divorce. Okay. The statement given by Delhi High Court was, whenever a person solemnizes marriage under this law, by this law it is Special Marriage Act, then the marriage is not governed by personal laws but by the Special Marriage Act. Alright, so this is where the Delhi High Court's role comes in. Alright, now what are the implications of this judgment which you can deduce? The law was passed in order to promote interfaith marriages. We have already discussed that. It is in line with the mindset of the changed times in a secular nation. Okay. You can in a way say, when we study in GS1, secularism Over there you can also talk about how the state has taken steps for promoting interfaith marriages through the SMA, and in a way upholding the spirit of secularism, the Indian way of secularism. Okay, how it is, because Indian secularism is, in the case of Indian secularism, the state has the power to interfere and intervene in order to bring in certain religious reforms. Okay, in this case the state has come out with the SMA in order to promote interfaith marriages. This is also in line with the changed times in a secular nation. Now, why was the SMA in the first place enacted? I told you an example of a Hindu marrying a Muslim. Let us say one of the communities does not agree with the marriage, and the parents of one of the communities, one of the parties, might affect or might attack the other party. In certain instances, as you can see here, it may endanger the life or limb of one of the other party due to parental interference. Now, in this case, the Hindu-Muslim case, let's say the marriage had occurred either under the Hindu law or under the Muslim law. Now, both these cases would have been detrimental for either of the persons. Okay, which is why the Special Marriage Act was brought out in the first place. Another important feature of the Special Marriage Act was divorce also would be governed by the secular law. Alright, and maintenance of a divorced wife would be along the lines set down in the civil law. Civil law, again SMA guidelines. Alright, so this law in a way upholds secularism. Okay, and this you can also, this judgment you can also use thus as to how the Delhi High Court stood up for women who could have been affected by the personal law had the Delhi High Court not given its judgment. Okay, it also says a lot about succession. The succession rules also apply according to the civil law of SMA. Alright, then this example can also be used to praise the judiciary when you can talk about how it has acted as a interpreter of laws, interpreter of the statutes of the country. All right. Another important example where this judgment can be used is the judiciary stood up for various cases such as khap panchayats or honor killings which might occur. Now, this law in a way protects certain marriages. So, the judiciary, by giving the power to the family court, has in a way increased the authenticity of the Special Marriage Act. Alright, so there are certain examples, certain areas where you can use this judgment. And according to me, this is a very important judgment. In a way, you can somewhat link this to Uniform Civil Code as well. Although not directly linked, but in some ways it can be linked. Okay, anyhow, we'll move on to the next judgment now about begging. So what the High Court did in the case of begging. Okay, 1960, we'll see a brief history of what had happened. The act of begging in the national capital was made a criminal offence after the Bombay Prevention of Begging Act of 1959 was extended to Delhi by a central government amendment in 1960. So the act was extended to Delhi. Okay, the Bombay Prevention of Begging Act and the Begging Act was made a criminal offence. In 2018, the Delhi High Court said that the law which made begging a punishable offence, those provisions have been quashed by the Delhi High Court. Those provisions have been declared null and void. Now, about the law which criminalizes begging. Now, there are certain provisions under the law. The law prescribes a penalty of up to 3 years of detention in beggar homes in the case of first conviction. So, in the case of first conviction, it gives 3 years detention. In the case of second conviction, the person can be detained for up to 10 years, less than 10 years, less than equal to 10 years. So, the person can be detained for less than equal to 10 years. Almost 20 states and 2 UTs have enacted their own legislations or adopted the legislations enacted by other states, and they have criminalized begging. So it is a criminal offense in 20 states and 2 UTs. What the Delhi High Court noted down in this judgment was that, read this very carefully, the state simply cannot fail to do its duty to provide a decent life to its citizens and add insult to injury. It's like adding oil to the fire. Add insult to the injury by arresting, detaining and imprisoning the person who begs in search for essentials of bare survival. Now, what the Delhi High Court said over here was, let's say a person is doing begging. First problem is that the state has failed to provide bare essentials to the person. Secondly, the state is imprisoning or detaining the person. Okay, now this is, in a way, you can call it a double jeopardy, which is occurring in this case. All right. Then the Delhi High Court noted that criminalizing begging was the wrong approach to deal with the underlying causes of the problem. All right. What the Delhi High Court meant over here was that unless the state is able to solve the underlying causes of the problem, criminalizing beggars is not the right way to go about. All right. So this is a very important judgment when it comes to especially GS4 in ethics. Someday or the other you will definitely get a case study regarding begging, whereby you can get a case study that the problem of begging has been rising in the country, or it has been rising up across traffic signals. Over traffic signals, they have become a menace. Almost they'll call it a menace. How will you tackle it? Over there you can always quote this judgment saying that the Delhi High Court has given certain rules that criminalizing begging is the wrong step to go. What the right step is to deal with the underlying causes, the first step, and then you can go about criminalizing begging only if the underlying causes are being addressed by the state. So this can be very beautifully utilized in GS4. In GS1 also, where we talk about various vulnerable sections of the society, where we talk about women, elderly, children, scheduled castes, scheduled tribes and all that. Over there, beggars also form a vulnerable group. All right. So over there also you can use this judgment and say what is the right way of dealing with beggars and what is the right way of dealing with the act of begging. All right. So this is how you can use this example. Okay, now we'll move on to the last judgment which was given by the Delhi High Court. Another important judgment. Before we actually talk about the judgment, I just want to give you a brief overview of what the Territorial Army actually is. So what is a Territorial Army? It is an organization of volunteers who receive military training in order to be mobilized for the country's defense in case of an emergency. It is also known as the second line of defense after the regular army. Now, this point over here, one of the criteria to be selected is that an individual should be well settled and employed. Okay. Then, those interested can join the Territorial Army from the age of 18 to 42 years. Okay. Now, here you don't have to join the regular army. You are a part of the second line of defense and you are not a part of the regular army. Alright. Now, a very famous personalities have also become part of the Territorial Army. Some of them are Kapil Dev, MS Dhoni, Sachin Tendulkar. Our MP Anurag Thakur is also part of this. Now, what was the judgment? Now, before this, January 2018, the Territorial Army was open only to men. As per section 6, which uses the word any person can be recruited, the Delhi High Court said that any person means both men and women and not merely men. Clearing the path for induction of women in the Territorial Army, the Delhi High Court in January said any provision which bars women from joining the force is against their fundamental rights provided under the Constitution. So it is directly against Article 14 first of all, and also against Article 21, because the right to choice is being taken away. The claimed policy is neither reasonable nor rational and has to be quashed. Neither reasonable nor rational. Hence, this was observed by the High Court, and hence this provision has to be quashed. Now, how this judgment can be useful? First of all, women empowerment. You can always use this judgment. How the judiciary stood up for women empowerment, or how the judiciary stood up for increasing female labor force participation rate. This is also a major issue which you can see in news these days. Then also, you can directly get a question about critically analyze should women be inducted into the army. Okay, over there you can analyze this, that if the Delhi High Court has upheld it, then yes, they should be inducted. However, proper training should be given so that they can become as much capable as the other persons of the army. Also, there is something you need to understand in the background over here, is that the army, the military, the regular military, the navy and the air force have not only allowed women for recruitment, but they have also recently allowed women for combat roles in the three forces. It was very strange that the territorial army had yet not even started recruiting women into their force. Okay, so combat role is the next step. So in the military, navy and the air force, the women were allowed for non-combat roles, but recently in the past 2-3 years they have been allowed in the combat roles as well. Okay, so the territorial army should also have taken the steps, but these steps were taken by Delhi High Court. So this is another famous example of judicial activism. All right, so concluding this video, I'm sure you might have gained a lot from the video, and I just want to tell you that all these examples can be readily used in essay. GS1 I have already told you in communalism part, GS2 judicial activism part, GS4 various case studies. So this video I'm sure should have a lot of application for you. If you have any doubts, any comments or suggestions, please mention them in the comment section so that we can address them. All right, till then, all the best.